The topic of the first panel is really looking at a lot of what the conference wants to do, which is how do you put property back into intellectual property? That may seem odd because it's called intellectual property, but there's a long-standing debate, especially among commentators and scholars, about whether it really was supposed to be property or whether that's just a recent name. So part of my argument that I was addressing today in the panel is that we have to see that there's at least 4 different kinds of property in what we call intellectual property today. The first is this notion of a private sphere where I have ideas in my head, and those are very much my property. That's not the subject matter of intellectual property. That's a natural property right that I shouldn't be forced. No one should torture me to get my ideas out of my head. To get things to come out of people's heads and be put out into the world in a useful way, states then created, nation states, created statutory law to say here's an incentive for if you put it out in the world, we'll give you an extra layer of rights with strong certain kinds of penalties if people infringe it. Also, once people do put things out into the world, they make copies of them, copies of books, copies of machines. And in those things then, there can be title and property to that as personal property, meaning an automobile I have as my property as as a physical thing, as well as it might be covered by patents and perhaps copyrights. So that's another level of property involved here. And the final one is if I do lease a car, there's a contract that I have. And that contract, I can buy and sell that contract. I can assign it to someone else under the right conditions. So those are at least 4 layers of property, and a lot of the debate now gets stuck by conflating them together, making it as if there's one kind of property. And I think that's where a lot of the confusion is stemming from today.